Good morning, everyone. It's Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, the first thing I wanted to talk to you about is we've heard a lot in the news and probably been more quite recently about denaturalizing U.S. citizens, taking away U.S. citizenship from people. And so I wanted to kind of break that down and what that means. So Department of Justice issued a memo recently, last month-ish, sort of maybe a month ago now, essentially saying that denaturalization or taking away citizenship that has been granted to individuals that were not born in the United States is at the top of their enforcement list for their civil division. So what that really means is they're going to probably use some of the funds that they were just given through the reconciliation bill and really kind of look at applications that they believe are eligible for denaturalization. So denaturalization is not you getting a letter in the mail saying that you're no longer a U.S. citizen. There is a process to taking away someone's U.S. citizenship that they acquired through naturalization. They will get a notice of intent to revoke in the mail, and then then they'll be given an opportunity to respond to whatever the allegations are in the notice of intent to revoke. So reasons that applications can be sort of on the chopping block for denaturalization are if somebody misrepresented or lied, let's just call it what it is, if somebody lied in any of their underlying immigration applications, if they lied about a fact, if they concealed something from the immigration service, if they willfully did not tell the immigration service something, if that something that they did not tell the immigration service is what we call material. So if you concealed or lied about or specifically withheld a material fact of an application, the immigration service can come in and move to revoke your U.S. citizenship. But again, it is not a situation where you will get a letter in the mail and poof, all of a sudden you're no longer a U.S. citizen. There is indeed a process to this. So, if you didn't conceal any information or you didn't, willfully lie on your application, I don't know that we're going to see very large numbers of people who will be denaturalized. But I did want to talk about that because I have been getting several calls about that recently. So I hope that information is helpful. If you want to talk more about your individual circumstance, feel free to reach out to the firm. We are happy to have that conversation with you. Next thing I want to talk to you all about is the H-1B cap season. So H-1B cap season is coming to a close with respect to another lottery being run. There will not be another lottery. USCIS has said that they have enough applications already submitted so that they can reach the mandated 65,000 new applications for a regular cap and 20,000 new applications for individuals that have received a master's from a U.S. school. So we are now just sort of seeing, people like myself, my colleagues, we are filing, we are waiting for applications that will all have to be filed before June 30th. So we're just kind of waiting for those to really kind of find their way through the system through USCIS. So there will not be a second lottery run on this year's H-1B cap season. So to that respect, it's almost over. Now we're just waiting for applications to be processed. So we know that recently ICE, Immigration and Customs Enforcement, through DHS got a significant increase in their budget. What my crystal ball tells me, given now that they have a budget increase, I expect to see more workplace raids, more coordinated workplace raids. So not just ICE going in, but ICE reaching out to and working with local law enforcement, going on to work sites and specifically looking for people that are not documented and are not eligible to work in the US. Along with workplace raids, my crystal ball also tells me there will be an uptick and an increase in I-9 audits. So when there is a workplace raid, typically ICE will also begin an I-9 audit. So if you have employees and you don't know what an I-9 is, if you have employees and you know that your I-9s are not as, shall we say, up to date and in compliance as they should be, or if you don't have any I-9s at all, give us a call. We're happy to help you get your I-9s into compliance. The I-9 audits are serious. As a result of an I-9 audit, you can be fined for mistakes that are found in your I-9 audit. So you want to make sure that your I-9 audits are in good shape. So again, if you have any questions about those, let me know. And the last thing that I wanted to talk about this morning was sort of a teeny blip coming from the Supreme Court, which has a pretty big impact on the state of Florida. So not too long ago, National Public Radio, NPR, reported that the U.S. Supreme Court essentially declined to sort of revive a provision of what Florida is calling its own immigration law. So part of that law enacted by Florida, which would only be applicable within the state of Florida, essentially said that it would be unlawful for an individual who is undocumented in the United States to enter into the state. So the lower court said, well, you can't really do that. That really is a federal court, or I'm sorry, that really is a federal government decision. So it wound its way up, all the way up to the Supreme Court, and the Supreme Court said, state court, you kind of can't do that. So the end result is that it leaves the state court block in place. So Florida cannot consider it a crime for undocumented individuals to enter the state. So that ban, the ban on that particular piece of law is still in place. It will most likely continue to wind its way through the system, and we will see if it is tweaked or changed in some way, shape, or form. And if so, I will let you know. That's all I have for this Monday morning. So have a great Monday morning and a beautiful rest of your week. Bye.